The evidence will show that on November 17, 2016, Laura Barca was found in her apartment in Wichita, Kansas, sitting on her sofa, deceased. She was all alone. She had died from a gunshot injury, and her 6-day-old child was not in the apartment with her, where she had been earlier in the day. And the defense hopes that as you consider the evidence, you'll think about some pretty serious questions. Whether or not this was an intentional premeditated murder to kidnap a child, or whether this was a lesser form of homicide, or whether it was an accident. The evidence is going to show you a great deal of information. Many witnesses, many pieces of evidence that you've already started to see. Definitions are going to be important in this case, and they're going to be important in your role as jurors. 4 critical definitions are going to talk about premeditation, intentional conduct, knowing conduct, and reckless conduct. And I'm going to talk to you about these briefly, and that's going to be the substance of my opening today. The evidence may or may not show premeditation, so you have to consider what is premeditation. Premeditation means to have thought the matter over beforehand. In other words, to have formed the design or intent to kill before the act. And although there is no specific time period required for premeditation, the concept of premeditation requires more than instantaneous, intentional act of taking another's life. So that's one concept for you to consider, and you'll consider that as you think about the evidence as it comes to you. The evidence may or may not show intentional conduct. What is intentional conduct for you to consider? Intentionally or with intent means a defendant acts intentionally when it is the defendant's desire or conscious objective to do the act complained about by the state, or a defendant acts intentionally when it is the defendant's desire or conscious objective to cause the result complained about by the state. So you will have that to consider. Those are first 2 critical definitions that you'll have to think about. Knowingly. The evidence may or may not show that the conduct of Ms. Sesmas was knowingly done. So you have to think about what that means, and you may be instructed about that by the court. A defendant acts knowingly when the defendant is aware of the nature of her conduct that the state complains about. Or alternatively, a defendant acts knowingly when the defendant is aware of the circumstances in which she was acting. Or lastly, alternatively, a defendant acts knowingly when the defendant is aware that her conduct was reasonably certain to cause the result complained about by the state. And lastly, you may see evidence of reckless conduct in this case. You'll have to decide, was this conduct reckless? Reckless conduct will probably be instructed to you by the court. A defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that certain circumstances exist. Or alternatively, a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that a result of the defendant's actions will follow. The act by the defendant disregarding the risk must be a gross deviation from the standard of care a reasonable person would use in the same situation. So those are your major questions. Those are the major questions that we think that you will have to consider. The defense is requesting that you render a verdict of not guilty based upon any reasonable doubt that you have about each of the charges. And absent a verdict of not guilty on the homicide count, we ask that you give very serious consideration to whether an appropriate verdict of a lesser homicide offense is appropriate. And those may be in 3 different forms. That may be intentional second-degree murder, or unintentional but reckless second-degree murder, or reckless manslaughter. And we ask that you keep in mind the burden of proof that you place upon the prosecution and the presumption of innocence. Thank you.